Rohit, welcome. Thank you so much. If you could make a short introduction of yourself, and then we just get it quickly started.
Thank you. I represent Singhania & Company. It's a pan-India law firm based out of Delhi, Bombay, all the major metropolitans. We've been there since '69 and have been pioneer in encouraging global investments in the country. And amongst the Fortune 100 companies, we've represented Microsoft, Airbus, Boeing, so a strong presence in the international fora. And today we are talking about another topic which is very upcoming from a global perspective, that is recognizing litigation funding as an asset class. So we've been having a lot of discussion on NFTs, blockchain, newer technologies that are getting recognized as an asset. Litigation funding, which traditionally has been there in UK and other jurisdictions, was restricted in the Indian jurisdiction till now, but recently in 2017, the Supreme Court of India has given a clear finding that litigation agreements are allowed in India. And after that, we are seeing a lot of interest from funds, both in India and abroad, to set up litigation funding as an investment asset class in the country.
Thank you, Rohit. I don't know how the remote works, but maybe just, yeah, if you can just stay close to your slides. I think it was yesterday in one of the sessions, one of the speakers was pointing out the relevance of litigation, not only as resolving conflicts and coming to a solution or a verdict for the parties, but also looking at it from a business point of view, as a business case. And that is actually what has also interested me a lot, looking into the topic of litigation fundings for a lot of people with assets, with investments, with capital, to somehow facilitate or support a litigation procedure or a trial while they can make money and while they can help others by supporting and putting the money in to fund the litigation proceedings. And now actually with a bit of more focus, how it works also in your jurisdiction. And then what is the global impact and how internationally are you practicing with litigation fundings from India to the world?
Sure. So based on the latest research that is happening, the current market size is around $12.5 billion. It is expected to go up to $25.8 billion, and out of which India is expected to contribute around $3 billion, which is sizable from the current market size, which is almost negligible. So as we say that whenever there is a problem, there is somewhere opportunity disguised as a solution. So this is a huge opportunity for the international funds, for the international market to consider litigation finance as an asset class. Now, a broad comparison between different asset classes and the returns that we are talking about, compared to the traditional or the conventional asset classes like equity, debts, bonds, litigation finance gives an interesting flavor or a diversification to the portfolio. Now, from an Indian jurisdiction point of view, typical stats say that around 75% of the cases are disposed of in 8 years. So if litigation is considered as an investment, typical estimate is an 8-year horizon from the returns perspective for realization. So from a longer term point of view, depending on what stage the litigation is, it can be an interesting proposition for setting up a fund, including this as an asset class. Now, one of the major assets which are part of litigation is land, where traditionally 2/3 of the litigation in India relates to land. Now, land, as we know, not only has an inherent value at present, but that also appreciates over time. So by the time the litigation gets over, the value of land itself increases, thereby the returns which are estimated at the start also chance a point of increasing further. So that even adds more value or make it more lucrative from an investment perspective. Now, from a legal framework, the Supreme Court of India has categorically held that the agreements are valid. So that has settled the issue over the legality of it. The qualifier or the rider there is that lawyers cannot get into a financing arrangement directly. So there can be a third-party fund or there can be a third-party investor which can get into such arrangements, but lawyers or law firms cannot directly engage in it. Now, as on date, there are no legislations or regulatory authorities, but under the common law, which the Indian jurisdiction follows, if the returns are exorbitant or if the returns are held to be arbitrary, they may stand a risk to be declared as void or against the public policy of India. So that's a check that needs to be imbibed in the agreements before entering. Now, from a global perspective, when we are looking at foreign funds setting up in India, the foreign law or the foreign investment is regulated by the Foreign Exchange Management Act, which allows, it's a positive legislation and allows investment in multiple asset classes, which includes undefined asset classes. So it gives a clear mandate that if the funds are interested, India can be explored as an opportunity to invest in these asset classes.
I have a question, I mean, not myself maybe, but I forgot also to mention to our esteemed friends and audience that you can, as I said, this is going to be a short and very interactive session. So Rohit is going through different passages, and in the meantime, if you have questions, we don't do it like at the end. If you have something maybe to mention, to comment, or to ask right now, please. The mic is coming, yeah. Yeah, so that we go really through each chapters every 2-3 slides. Feel free to share your comments, because I think this is a very, very interesting and attractive maybe for non-Indians to involve.
Regarding your comment on voidable or void contracts where fees turn out to be excessive, I think it's very difficult for any claimant to assess that fees of law firms are excessive, because they can create number of hours worked on the case that are totally out of whack. My question to you is, do you see an opportunity for creating a fair price for the services to be provided in these litigations, that tenders will take place among law firms vying for such litigation? Or do you think it will be sole sourcing, going to one law firm doing it? Because from a perspective of an investor, I would like to have the best law firm for the lowest price, and then you sometimes see that the most expensive are per hour are cheaper than the ones that are cheaper per hour but take longer in hours.
Fair point. So a slight clarification here. There is no restriction as to the fees of the lawyer. There's no capping on the lawyer's fee or the law firm's fee. The capping is on the return. So for example, a fund invests into an asset class. The owner of that litigation, who assigns the litigation, that return needs to be reasonable. So for example, in a recent case, there was an agreement between a landowner and the investment fund, and the investment fund took 3/4 of the revenue generated in that land. So that was held to be unreasonable, that 3/4 of the total proceeds were exorbitant or too much. So that's the rider. There is no rider on the law firm's fees per se.
Sorry, you said that there is no contingent fee, if I understood correctly.
That's right.
What about conditional fee arrangements, in the sense one part fixed, part variable, with the part variable being substantially high?
Strictly speaking, the conditionality part is looked down upon, though there are innovative structures, but typically it's looked down upon or in a way prohibited. There is no cap on the amount per se. So even if there is a high fixed fee or a high hourly rate per se, that's absolutely okay. That's a private arrangement between the client and the lawyer.
Really good points. Any other comments before we move on? Okay. Let's go. Maybe, yeah, exactly, for the also global relationships and the non-local players.
So from the cross-border perspective, now another interesting proposition that has come up of late is the financial center which has been set up in India. So that's the first financial center in India for offshore funds and investments. And the regulations have been notified very recently, last month in fact, which give a composite overview as to how the funds have to operate and how the investments can be repatriated, specifying the minimum caps, the floor, the ceiling, all the knows-hows, how the funds can operate. And that can be an interesting aspect for foreign funds and foreign investors to consider. So the biggest advantage that the financial center strives to bring is easy repatriation of the profits in an efficient, tax-optimized manner. So that's an interesting piece that can be considered for setting up a fund investing in the litigation as an asset class. Now, moving to the next topic regarding tokenization.
Wait, because there must be actually a transition to that I'm very happy that you're covering that part, Rohit. I mean, most of you were also yesterday in the session regarding decentralization, NFTs, also IPs and data privacy issues. So let's say we delivered a compact overview over the legal and compliance challenges, but at the same time, I'm happy that Rohit is going to cover now with regards to assets and tokenization in litigation funding, which is a direct link to the legal industry, actually, and also investments. What we discussed also yesterday was that still there are not clear laws and also regulations, and only like very few countries are already there who have already regulations in place. So it means that in these countries, including now Dubai since March, Switzerland since 2020, United States since 2020, they discussed and they decided to enact, but it's still not so far, that they're not as far as Emirates and Switzerland are. But exactly that makes it now gray and at the same time challenging and an opportunity for lawyers now to see how to still be able to retain clients, to maintain the clientele relationships and protect their interests and their assets in the absence of clear laws and regulations in the area. And this trend is just happening, and it's happening immensely. The whole decentralization is taking over different industries, and in the absence of clear laws, and also in most of jurisdictions, also the judiciary is not clear on how to implement, how to practice, and how to rule if a dispute or a conflict is arising. And now, interestingly, throughout the past, especially throughout the past 1.5 years, the tokenization has been also now covering other areas than just cryptos and people who are interested in like digital currencies and DeFi as such. It has now found its way to real estate, to other asset capitals, to art, to sports, to tourism, healthcare. So it is like really explosively and immensely expanding, while there are still not frameworks. And actually the whole philosophy of blockchain and decentralization is that we don't want any authorities, we don't want any law, we don't want any regulations. That is actually what decentralization as such means. So they don't want to be governed or ruled by a centralized authority. And exactly seeing that conflict and that interest and the whole meaning and philosophy of blockchain, and now seeing, yeah, that opens doors also for criminal behaviors, for fraudulent behaviors, for breaches of commitments, as we had in the first session. I think it was Nagla who was talking about that $300 million deal of the Japanese with the handshakes, or multiple of those kind of commitments and arrangements, especially during the 80s. These may not be really well secured in the decentralized world. And now, looking at it a bit more specifically, Rohit is going to cover the impact of tokenizations also in the litigation funding. In the past couple of months, we have seen already like court verdicts coming up as NFTs, or maybe punishments or fines being issued as NFTs. And I think one of the UK courts was pioneering in this area. And that makes it open also to the lawyers, because our industry is, if we want it or not, is unfortunately always behind with technology and innovation. And it's good to open the doors for non-lawyers, for those who are the service providers exactly in these areas, to start collaborating with them, interacting with them, and letting them in, if they're investors, business people, tech people, artists, to come in and say, what are they expecting from lawyers or legal professionals to bring into this new wave. As we said, this is happening, decentralization is there, either we want it or not, so it's better to be well prepared and well educated and well informed on how it impacts different areas, and now specifically litigation funding. If somebody has a comment or question, maybe prior to Rohit's clarification, you can state, so that maybe he can also cover your comment or question, or he just goes in. Because this is, as I said, a joint session with you, not only with me and Rohit. Then go.
Yep. So now litigation funding as an asset class, like all other asset classes, tokenization opens up an opportunity to lower the entry barrier, to make it better managed, to increase the liquidity.
Excuse me, Rohit, does everyone knows what a token is? I mean, let's be honest, it's fine. Everyone knows what a token is? Okay, a token is a digital asset. It's like a coin, it's like a whatever. I mean, you have maybe a house or a car, that's a physical asset, and a token is a digital asset which is defined by a series of codes. And for a lot of people that yesterday were also asking, we have non-fungible tokens and fungible tokens. Fungible tokens are those that are exchangeable, replaceable, and you can exchange them with one another. Like, for example, if this is in digital form and you can exchange it with one another, that's just a token, like also the coins, all digital currencies like bitcoins and anything else. But the non-fungible token, especially which stands, the NFT stands for, non-fungible tokens, they are those which are not replaceable and not exchangeable. So they are unique and individual series of codes. That is a definition of token, and now we had fungible and non-fungible. And tokenization is the process of transferring let's say, a physical asset to a digital asset. And that digital asset or that token would be the access card or your entry code or your certificate of authentication to that asset, to that physical asset. That is how it's happening, especially in Dubai. I mean, if we're talking about like the Arabian regions, Sheikh Mohammed has opened up a lot of opportunities and doors for tokenizations of real estate. And now it's booming in the whole Emirates. Awesome business, and at the same time, it's just, and Dubai is now building the first metaverse city as a whole. So this is just an insight, because it would make no sense if you just go through tokenization and if we don't know what a token is. Let's go.
Yeah. So, taking the example of NFT, now NFT derives its value from exclusivity, how exclusive that token is, right? Now, we are considering tokenization of litigation funding, where we are considering a particular litigation where there is an asset or there is an investment which is foreseen, and that is tokenized into a token where the investors or the buyers have invested and taken in those tokens. So now the critical aspects which come into the picture is that how do we add or how do we derive value to that particular token? So that becomes an interesting proposition, because like an NFT, the value being intangible in terms of the desirability, in terms of the exclusivity, here there is an asset where there is a value attached to it. So for example, if there is a particular litigation where the claims or the expected claims are worth $1 billion, so that's a tangible value that is attached to that particular asset class. So there, how, or the number of tokens that are created, there is an inherent value to it which can act as a threshold and can then be replicated to derive a value to that token. So in that aspect, we feel that maybe tokenization of litigation funding as an asset class will be more directional and plausible, and rather help in reducing the entry barrier. For example, if the entry barrier to fund $1 billion expected claim litigation is 3% or 4% of the expected claim, for example, this can help divide or tokenize the cost and thereby increase the liquidity of that. And then at subsequent stages of litigation, it will give an advantage of exiting rather than waiting till the end of the litigation for the exit to happen. So it can make
typical freedom in connects with decentralization. So there's like no, let's say, bound so that you have to tolerate something until the bitter end. There is always a kind of exit door open. And that is what we have normally in the physical world. In the contracts, we always have also an exit clause or an exit strategy. What happens in case of disease, in case of any problems, that bankruptcy or a dissolution of a partnership, a kind of exit, what happens? And now we have it already in the decentralized world, that it's much more facilitated, and it gives this freedom of choosing whether you want to stick to it, whether you want to stay committed, and take the consequences. Efficiency and freedom. 2 questions or comments. Can I know your name? Sorry, because...
Yeah, sure. Does it work? No, it works.
You just pressed for 3 seconds and it works.
My name is Paul de Jong.
Paul, okay, because you've been always very
that's
active.
fine. No, sorry, I should have done that before.
And then
Just to get the definitions right, when you talk about the value derived, don't you mean the value attributed? Because there's a difference between that. I mean, when you attribute a value, you say the value is this. When you derive a value, it's like a consequence after the fact. So my question is, when you go into this tokenization, is it not that you're attributing a value rather than deriving a value?
So if you take the example of an NFT, there is a value that you are attributing to it. But in a litigation funding, there is an underlying litigation which already has a plausible claim or which has an inherent value. So that is where the thin distinction is. That when we are talking about tokenization of a litigation funding, there is already a plausible value that the litigation claim is expected to bring. So that is why you are deriving that value based on that plausible claim that is realizable. In an NFT, you are attributing the value based on how exclusive it is, how many copies there are, what's the desirability of that particular NFT. So that's the thin line of difference.
Thank you so much, Paul. Stefano.
But the token has a nominal value, correct? In the sense, it's like a share, and you say you give it a value. And you're saying that you lower the entry barrier, which I can understand, because you have, let's say, legal fees for $300,000, and you can sell various tokens to a number of investors. But if you have to face legal fees of $5 million in a major arbitration, for instance, it becomes much more difficult. So does the token restrict you to claims with a lower value and therefore with lower legal fees? Or you have seen cases where they can be used also for bigger tickets items?
I would believe that even for bigger ticket sizes, the principle would remain the same. So even if larger ticket sizes where the fees is $5 million or above, if it's getting divided between 10 investors, the per investor entry barrier becomes lower rather than one investor having to bear that $5 million check. So I believe that even for larger ticket sizes, the principle would stand.
Maybe we add one sentence to that as well. I'm very happy that you brought that up, and it opened now maybe a door for one further additional comment. It's also the principle of fractionalization of the assets in the decentralized world as well, for some tokens, for example. I mean, if like now given that litigation or that asset is considered as a token, the possibility to open the doors for more than one investor to get in and facilitate that process, that makes it possible for them to have fractions of that token. And that's the facilitated entry level and also facilitated exit strategy, because if one investor exits, not the whole process will be damaged or, let's say, exactly, disturbed.
And it will also increase the liquidity. So it will become like a multi-entry, multi-exit process, where suppose if somewhere you need a liquidity as a fractional investor and you want to exit, so there are opportunities for other fractional investors to come in and exit for you at a multi-exit stage rather than waiting till the end of the litigation.
I remember yesterday in the NFT sessions that we emphasized on the importance and the relevance of community. That is actually what the whole DeFi also brings along. It is not only that freedom of action and investment and anonymity and privacy, it is also that building community. And as we see it also in Latin, we said ad fontes, it is that back to the basics, human beings, after now all these years of the course of decentralization, digitization, globalization, people have become very lonely, and now they're seeking back, getting back together. Social animals, building communities, building a kind of like fractionalized possession where they share their rights and also they share their authorities around selling or owning or trading something, which we're calling it here a token. And the main purpose, or let's say the end impact of tokenization here, is resolving somebody else's problem by means of a litigation.
Yep. And look, sort of explaining from Indian jurisprudence or Indian jurisdiction's point of view. So there's the first court, then the appellate court, then the apex court. So say a typical investment in litigation funding, maybe an investor may want to exit after the favorable decision of the first court. There may be a challenge before the appellate court, but if a favorable decision has come in the first instance, there would be a positive sentiment about the litigation and the person may get an exit at that stage itself, rather than waiting for the longer end of the litigation. So it just adds in more value or makes the asset more attractive. So that's why litigation asset in general is becoming attractive. In addition, if there are attributes of tokenization added to it, it just makes the liquidity easier, it makes the exit easier, just makes the instrument as a whole lot more lucrative.
And one more advantage of it is also it opens the door for younger generations to get involved in this kind of processes, investments, and also litigation funding. Because until now, we have seen litigation funding business has been rather a kind of senior business, because not every young person has a lot of money to invest in, or they just don't know. They do not have the knowledge or the experience about litigation. They are not maybe yet even graduated from law school or maybe business school to understand these things, or maybe they do not even have access to such funds. But the moment we open the doors by giving this freedom, the access facilitation, the freedom of exit, the fractionalized possession, so you suddenly bring the diversity in. So you don't have only one or two or three like senior investors like putting in millions somewhere, but then you see 2, 3 younger people are coming and putting in maybe 50K, and they are a part of this as well. So it's opening the door, and that's why maybe you see me talking about decentralization and tokenization always with a smile, because it's a part of my dreams have come true. Stefano, please. Yeah.
If I may make a comment, I guess one thing which comes to mind is the fact that it can also be used for litigations which are done for a good cause. I was thinking about ESG claims. Since you are really lowering the value of a token and lowering the entry level, I guess it can be sold, or they can be sold for legal actions which are considered to be a good cause legal action.
No, total important point. Yeah.
Sorry?
Yeah, crowdfunding. Thank you. Yeah.
Yeah, crowdfunding.
Yeah, or also litigations which are for a social cause.
Because it's a form of crowdfunding. You're raising money from.
Yeah, the formal crowdfunding is not necessarily involved with a legal action, but they are both actually parallel, very well secured by means of tokenization. And
no, in fact, yesterday the first session which happened, where the French class action suits were getting discussed. That was one of the points that was discussed, that if there'll be more crowdfunding, class action suits would gain more popularity in France.
Yeah, because class actions are typical ways of engaging a social cause as well.
Yeah.
Like for mistreated, workers or people who have not been really granted their labor salaries, etc. So other people want to have a share in that cause, and I'm happy that
you give access to justice to people who don't have access to justice.
There you go.
So far, the good side we just heard, that's crowdfunding. The negative side I see is that there's also maybe an avenue for people who are under sanction rulings to participate in it, which brings me in trouble when I'm in bed with these people.
Correct.
Who bring in funds to my joint fractionalized token.
Correct.
And probably the authorities have not thought about that yet, but I don't want to be in bed with a token fellow who is under sanction, because that brings me in jeopardy.
That's correct. And as long as you don't know it, actually, no matter if you know it or you don't know it, then that would be your own risk. And that is very right concern. And actually, yesterday we pointed it out within seconds about financial crimes, including AML, sanction, terrorism financing, tax fraud. So these are all parts and still unclarified or unregulated risks of DeFi, decentralized finance. So yes, and that is why actually lawyers are even asked to engage more, because to mitigate those risks, to consult the clients or people who are interested in getting involved in this kind of actions, to also raising awareness about the risks. Because me, myself, anytime I'm talking about decentralization and blockchain, I have that big smile because I love it. But at the same time, as lawyer, there comes the responsibility and say, tell your clients as well what would be the risks for them if this happen. It's not only the freedom and the cool, satisfaction of human being acting without authorities and getting involved in communities and making an impact, but there are also some gray sides, and you just mentioned one of them.
Yeah, so basically to sum up the topic, litigation funding as an asset class can be definitely looked upon, especially from the Indian jurisdiction. I think that's a great upcoming asset class that is being recognized. And tokenization adds more flavor, more sort of, attraction to it. So definitely an area where lawyers can get together, improvise, innovate. I think a good topic to really think through and, look at how various jurisdictions can collaborate on.
Thank you so much, Rohit. Maybe one question also from my side, and then maybe we take one more question also from audience, if there is one. How far is India with regulations? So, because that would also give non-local investors or people who want to engage in such a process in India, that gives them also maybe a kind of relative security that if they know there's something that may protect them if something goes wrong.
So India has started recognizing the litigation financing agreements. So the Supreme Court of India in 2017 came out with an observation that the agreements, there is no prohibition and they are legal. There was one recent judgment by one of the high courts which recognized the right of an investor and ensured that the agreement is enforced. So good time to sort of jump in.
Good time to jump in. So awesome. That would be a good conclusive statement. Any question or comment from you awesome hungry people? Yes. Ali is, Ayman is hungry. Yes, hungry or yes, question? Okay, so we're all hungry, angry and hungry. Awesome, thank you so much that you kept up so long, and let's enjoy lunch. Thank you, thank you. And